Hello, friends and clients of JLW Immigration Law Group. I am Jennifer Walker Gates. I'm here today to talk to you in this video about how you can adjust status in the United States, even if you entered without permission. This is really important for people to know because for the most part, people who are becoming lawful permanent residents in the United States who did not enter with permission are not eligible for adjustment of status. That is kind of the general rule. And I get this question all the time. Well, I have a friend who entered like me without permission, but he was able to get his green card without leaving the US. And I hear clients all the time say, I don't want to leave the US. That's very scary and stressful. And what if I don't come back? What if I don't get approved? That doesn't feel comfortable. I want to do it here. As a general rule, if you enter the United States without permission, and then later you become eligible to get your green card through a family member, usually a spouse who is a US citizen or a lawful permanent resident, if you didn't enter with a visa or with permission of some sort, then you have to leave the US, go to a consulate. After you've gotten a waiver for having entered unlawfully, go to the consulate and get your green card there. We're going to be talking today about the different ways that people might be able to get a green card in the US, even if they did not enter with permission. So if one of your friends who entered unlawfully ends up getting his green card or her green card without leaving the US, they get it in the US, even though they didn't enter with permission, it's probably because they have one of these types of cases. Okay, so we're going to be talking about these exceptions to that general rule that you need a lawful entry to qualify for adjustment of status. Before we get into all of that, please take a moment and subscribe to our channel. We are really hoping to get to 10,000 subscribers this year. Share the information, pass it along. But this is information that really can change someone's life. Certainly anyone who doesn't qualify for any kind of benefit, what we're going to be talking about today will help some of those people. People who only qualify for consular processing or think that they do could learn that they qualify for adjustment of status instead in the US. So this is information that is really important for the whole immigrant community across the United States, and that is who we're here to help. So please share, like our channel, subscribe, leave us a comment. I do respond to our comments, and I'm happy to help through the comments if I possibly can. All right, so let's jump into today's topic. As I was saying, usually, adjustment of status in the United States requires having entered with permission, having a clean immigration history, and in addition, you need someone, either an employer or a family member, to petition for you. If you are adjusting through an employer, you have to have entered not only with permission, but maintained lawful status intact the entire time you're in the United States. You have to have not worked without permission. Employment-based immigration really is the most restrictive in those ways. But even if you're trying to get status through a family member, if you're going to adjust status in the United States and not abroad at a consulate, you have to have entered with permission and then gotten married to a US citizen or have a US citizen child who is petitioning for you. That is the truth for most cases. So immediate relatives of US citizens can qualify for adjustment of status even if they fall out of status. So that means like if they entered with a visa, but then their visa expired and they get married several years later and they've been working without permission and they've had this unlawful status during the time that that weren't married to a US citizen, that's still okay as long as they entered with permission. But that lawful entry is so important for our family-based immigration clients and for any employment-based immigration client. That lawful entry is crucial to be eligible for adjustment of status and to be able to avoid having to leave the US to get your residency approved at a US consulate outside the country. Now, here is a list of the types of cases that we're going to be talking about in this video that are exceptions to this general rule. Number 1, 245I. Number 2, VAWA. Number 3, U visas or T visas. Number 4, asylees. Number 5, advanced parole. 6, parole-in-place. 7, humanitarian parole. 8, cancellation of removal. And 9, special immigrant juvenile status. Okay, most of these cases come through our humanitarian immigration system. That is where most people find the ability to become a lawful permanent resident in the US, even in spite of an unlawful entry. But we will be talking about each of these and not going super in depth in each one, but just kind of going over very general requirements for each one so that you have a sense of whether you might qualify for one of these benefits and thereby either avoid the consular process, get your residency within the US, or potentially learn that you qualify for something that you didn't know you qualified for. Okay, so 245I. 245I was a law that was created by Congress way back in the 90s. It sunsetted, so they called it, in April of 2001. So in order to qualify for what's called 245I, you have to have had a petition filed by a family member for you or for one of your parents where you are a dependent, or for an ex-spouse or where you are a dependent. You have to have either been a dependent or a direct beneficiary on a petition on or before April 30th of 2001 in order to qualify for 245I. You also have to demonstrate that you are physically present in the United States on or before December 21st of the year 2000. Now that is not true if your petition was filed before January 1st of 1998. So if you had a petition filed way back in the 90s for one of your parents when you were a minor child, for one of a spouse that you're no longer even married to, you can still qualify for 245I using that old petition if you have a new petitioner who can sponsor you. So it is important to investigate whether your family's immigration history can benefit you through 245I. Most of those cases have already been processed, but if you do qualify for 245I, you have to pay a $1,000 penalty, but it allows you to get your residency in the United States. It does allow you to apply for and qualify for adjustment of status. The second exception to the general rule that you have to have entered with permission in order to get your green card in the US is VAWA, VAWA self-petitioners. These are folks who have suffered either physical abuse or what's called extreme cruelty at the hands of a US citizen or lawful permanent resident, spouse, parent, or child. So if you are approved as a VAWA self-petitioner, meaning if you're found to have really suffered from abuse or extreme cruelty by one of those qualifying relatives, then your unlawful presence and your unlawful entry is waived, and you can receive your green card from within the United States. This is an excellent option if you have in fact suffered from some kind of abuse or extreme cruelty, but those standards are pretty high. Those are not just your average, ordinary, everyday child who misbehaves during their teen years. Abuse has to have happened when the child was over the age of 21 in order to qualify to petition the parent. In addition, the abuse has to have been real abuse. It can't just be that they had a bad attitude one time, that they snuck out of the house one time, that they broke curfew one time, that they made a couple of bad grades in high school. Those kinds of ordinary problems will not qualify for VAWA. There are some attorneys out there promoting VAWA as an option for families who really don't qualify and saying that average, ordinary, bad teenage behavior can qualify for VAWA. That is not my experience at all. So if someone is telling you that, please be careful, get a second opinion. Don't lose your money. Don't waste your money applying for VAWA if you don't actually qualify as a survivor of abuse or extreme cruelty. Now, if you do qualify as a survivor of abuse or extreme cruelty, VAWA is a really important case for you to know about. There is even a waiver in VAWA for the permanent bar, meaning for multiple unlawful entries, if you can demonstrate a connection between your multiple unlawful entries and the abuse. We have won these. We have seen this happen. It is an important provision for immigrant survivors to know about. So if this has happened, please don't hesitate to reach out to us. We will be extremely honest with you about whether your case can or cannot qualify for VAWA protections. Exception 3, U visas and T visas. These are visas that exist for cooperative victims of crime and human trafficking. These are people who have suffered from domestic violence, armed robbery, kidnapping, sexual abuse, different kinds of violent crimes, as well as human trafficking, meaning forced labor or commercial sex acts, who report the crime and cooperate with the investigation or prosecution of the crime. There is a waiver for unlawful entries. There is a waiver for prior deportations. There is a waiver for the permanent bar. There's a waiver for false claims to U.S. citizenship. U visas and T visas have some of the most expansive, broad, and generous waivers that exist in the immigration law. And so, although they can take a really long time to get approved, they are an excellent benefit if you are able to wait the amount of time that they take. They offer temporary work authorization to people who are waiting, and we have really been seeing improvements in the processing times for those bona fide determinations and work permits for our U visa clients. If you think you may have suffered a crime that qualifies for a U visa or a T visa, please reach out to us. This does put you on the path to lawful permanent residence in the United States without having to leave. And it is a really important benefit for that reason. So far, 245I, VAWA, U visa, T visa. What's next? Adjustment of status for asylees. Okay, if you entered without permission to the United States, but you were granted asylum either by the USCIS Asylum Office or by the Immigration Court, then a year later, after the grant of asylum, you will be eligible to receive adjustment of status if you apply. So in certain cases, if you're hearing from people that they entered without permission, but they are able to adjust status in the United States, it could be because they were approved for asylum. Advanced parole. Advanced parole is a benefit that can allow someone who entered the United States without permission to receive a permission to travel temporarily and return lawfully. We see this most frequently with people who have DACA and temporary protected status. Those folks can apply for a very specific advanced parole permit, travel permission to allow them to leave the US. Advanced parole is very special because leaving the US with advanced parole does not trigger certain bars that could prevent you from coming back. And in fact, you get to leave with a permit already in your hand, proving that you have permission to return. Now, of course, the border agents have discretion to block someone's return if they think that they have been involved in criminal activity while they were outside the United States. Other than that, we've never seen any difficulty or problem with any of our clients who were granted advanced parole being able to travel and come back. And if you do that, that can basically undo the negative effects on your case of having entered unlawfully before. Then if you have a U.S. citizen relative who is either an adult child or a spouse, or even if you have a lawful permanent resident spouse, but you have TPS, you could then qualify for adjustment of status in the United States once that other person petitions for you and if you meet all the other requirements. So advanced parole is another way that people who entered unlawfully may be able to adjust status. Now, parole-in-place is a special provision that exists exclusively for parents, spouses, and minor children of U.S. military veterans or active duty military members. Parole-in-place is a really important benefit that basically erases one unlawful entry from your record and allows you to adjust status within the United States. So, this has been most helpful for those parents of U.S. citizens who may have entered unlawfully and don't have any way to receive a waiver for that unlawful entry because they don't have a spouse or a parent who is a U.S. citizen or lawful permanent resident. Unlike VAWA, parole-in-place is very clear-cut. It's very easy to either qualify or not qualify. If your child is a member of the U.S. Armed Forces or the Ready Reserves, or is a veteran of either of those agencies, then they can qualify to petition for you, and you can basically receive a waiver of your unlawful entry and adjust status in the U.S. Number 7, humanitarian parole. Individuals who enter without permission but are later granted humanitarian parole may qualify for adjustment of status as either an immediate relative of a U.S. citizen or as a relative, a spouse, minor child of someone who adjusted status through the Cuban Adjustment Act. That is what this CAA stands for. So an unlawful entry by itself, you don't qualify as an immediate relative or through Cuban Adjustment Act. But if you receive a humanitarian parole after you have already entered unlawfully, that will allow you to then adjust status. Those humanitarian paroles are really only available for people who have, a serious medical condition that they're dealing with. Maybe either they are very, very ill themselves, or they have a child who is profoundly disabled or ill. Some spouses of Cubans may receive a humanitarian parole. Some people who are detained upon their unlawful entry may receive a humanitarian parole if they have some kind of serious medical issue or some other very compelling humanitarian circumstance that can convince USCIS or Immigration Customs Enforcement to issue a humanitarian parole to that person. It functions a little bit like parole-in-place in that you are in the US already, and then you receive this humanitarian benefit that then allows you to apply for adjustment of status. So very rare, but it does exist in the law, and humanitarian parole may be another way that you can get qualified for adjustment of status in spite of an unlawful entry. Now, another way that this tends to happen is through a benefit called cancellation of removal. Cancellation of removal is available for people who have lived in the United States for 10 years, have had good moral character for that entire time, and can prove what's called extreme and exceptionally unusual hardship to a U.S. citizen spouse, parent, or child. Now, it is really difficult to make that extreme hardship standard. That is hard. That's actually way higher than extreme hardship, which is what we see with waivers. But if you have a family member who is extremely profoundly ill or has had severe tragedy or trauma in their past, you can make this showing, and some people do get granted cancellation of removal. Now, there's also another benefit called VAWA cancellation of removal, and that is available for people who not only have, the time in the United States, which is way less, it's actually 3 years instead of 10, but they also have the abuse and or extreme cruelty by that U.S. citizen or lawful permanent resident relative. So if you qualify for cancellation of removal or VAWA cancellation of removal, then in spite of your unlawful entry, the court, the immigration judge, can grant you adjustment of status, and you can get your green card from within the United States. It does require going to court. It is not possible to apply for cancellation of removal with USCIS. You can't just send in an application for this. You have to be already, in front of the immigration court, which usually requires an arrest or detention by ICE. So it is not without its own drawbacks and stresses, but it is a benefit that's available that can be helpful for people who entered without permission and need a way to get their residency. Finally, special immigrant juvenile status is the last way that we're going to be talking about in this video for how a person might be able to get a green card even if they entered unlawfully. Special immigrant juveniles are kids who have been abandoned, neglected, or abused by one or both of their parents. A family court has to find that they are not going to be best served by going back to their home country, and that they are not able to reunite with at least one of their parents because of abuse, abandonment, or neglect. If that is granted, then they can file with USCIS. They file on that same form that a VAWA applicant, self-petitioner, files on. It's Form I-360. And if USCIS grants that Form I-360, then when it's their turn, after a few years, they can also apply for adjustment of status. And those kids are not required to demonstrate that they entered with permission. They are able to receive their green card through adjustment of status, even in spite of an unlawful entry. With all of this said, the rules still apply in general to say that if you want to adjust status in the United States, you have to demonstrate that you entered with permission, and you have to demonstrate that you have the proper qualifying relative, and that you meet all the requirements. You are not inadmissible. Your sponsor makes adequate income. But for cases that go into our humanitarian immigration system, the rules tend to be more flexible and generous. And so that is why sometimes you may meet someone who says, well, I entered unlawfully, but I got a green card. It's possible that they themselves processed through this humanitarian system, or that their spouse did, and they got to be the beneficiary of that as well. So if you think you may qualify for any of these, we would be thrilled to death to help you get your green card through adjustment of status in the United States and not go outside the US to the consulate if possible. Please reach out to us. Our number is 512-633-1785. It's scrolling along the bottom of the screen. You can also go to our website, which is jlw.law. And on that website, click on a button to schedule an appointment with me directly or with any of my partners or our associates at the firm. All of us know about these benefits. We know how to screen for them. We search for them every chance we get because these are really good opportunities for people who have suffered, who have been through a lot of difficulty and adversity and have overcome it, and have the opportunity to turn that adversity into something positive for themselves and their family members. So if we can help you qualify for one of these, we would be honored to do so. And if you don't qualify, we're going to be very honest with you about that. And we're going to talk to you about how to consular process if you qualify to do that. Because even though leaving the US to get your green card seems very stressful and scary, the truth is that thousands upon thousands upon thousands of immigrants do that every year. We have helped more than 1,000 immigrants get their green card through consular processing with waivers. We hold your hand and guide you every step of the way. And it is our honor and pleasure to do that. It allows our clients to get secure long-term lawful status in the US. And even though that is a very stressful process for some, it ends up in the vast majority of cases working just fine. I will say the one time it doesn't work is when you are not honest with your attorney about your immigration history or your criminal history. Those cases definitely can raise problems. So please, please, please make sure you're disclosing everything, every arrest, even if it was expunged, even if somebody told you you never had to bring it up, even if you were a juvenile, tell your attorney about all of that because it's still going to be important for your immigration case. Check out our other videos. We have others. If you do have arrests, we have others on consular processing. We have others on the waiver and how to win your waiver. Check out our channel, subscribe, like our videos, share them, leave us comments, be in touch. Let us know how we can help. Take care.